Yes.
My lords, I appear on behalf of Miss Al-Hayali.
Yes.
Both parties in this case have brought an appeal. My learned friends, Miss Darwin, KC, and Mr. Legg, appear on behalf of the embassy.
Yes.
We have agreed a timetable between us.
Well, that was my first question, so you're ahead of the game.
With your approval. What we were proposing to do with the court's approval was to take each appeal separately, to start with Miss Aliahi's appeal, but both parties, in dealing with Miss Aliahi's appeal, would wish to deal with some matters which we say are common across both appeals.
Yes.
So the timetable we have is that I will open on Miss Aliahi's appeal, and I will be aiming to sit down again at 2:30 this afternoon. Miss Darwin and Mr. Legg will deal with, and as I say, I will be dealing with Miss Aliahi's appeal and any common issues. Miss Darwin and Mr. Legg will start speaking at 2:30 this afternoon and sit down again at midday tomorrow. And then I will reply on Miss Aliahi's appeal between midday and midday. We will then deal with the embassy's appeal, Miss Darwin and Mr. Legg from 12:30 through to 2:30, me responding on the embassy's appeal until 3:30, with Miss Darwin and Mr. Legg in reply till 4 o'clock. I should say that that timetable presupposes that the court will not wish to hear from the parties on ground 2 of the embassy's appeal. You will see that ground 2 of the embassy's appeal, which is the psychiatric injury point, you will see that neither party dealt with that substantively in their skeleton, and we assume that the court will wish to follow the recent decision in Shahabi, which is on point.
Well, I think we've obviously discussed the case. That's a safe assumption.
I'm very grateful. Before...
So that timetable seems to be, in a way, that the work has expanded to fit the time available. I'm bound to say that part of our discussion was, as ever, as judges, optimism that matters could be taken more swiftly than that, particularly get through your case before the luncheon adjournment and the embassy's response and moving on after that.
I hear what you say, and it's a fair criticism in the circumstances. As I say, that's a timetable we've agreed, and I don't wish to go behind it without...
No, well, let's see. Certainly, unless either of my lords have a different view, that the order of events is one that we'd be comfortable with, and let's see how we go. And of course, when judges make a remark such as I've just made, it takes no account of the many interruptions that there'll be from the three of us, and so you may have been very wise to allow the time you've allowed. Good.
If I can be faster, I certainly will be.
Right. There's a live transcription. I don't think either, none of us have got it, and don't want it. And so, if you want to quote from it, you'll have to quote from it if you have it. I can see you haven't got computers either. But
I don't know. I do not have access to it. I think it's being paid for by the embassy. So
right. There we are.
I was certainly not intending to take you to it.
But I gave permission for a transcript on what I regard as the usual terms, which is at the end of each day, it should be provided to both sides and to us.
I'm very grateful, my lord. I'm sorry I didn't know that.
Is that correct, Miss Darwin?
We've provided Miss Stanley with access to it. I think she's just suggested that she's not interested in access to it, but she was sent the details, as I understand it. It was yesterday, so that she can log on and access the transcript if she wants to.
But my lords, from my point of view, my lord's point of view as well, as he just said it, having the physical transcript at the end of the day available to both sides and to the court is the attractive.
We can certainly extract it from the website and send it to Miss Stanley and to the court.
And to the court. Thank you. But the other matter is that it may be during the course of the court sitting we need to rise for a short time because one of us needs a comfort break. If we do suddenly rise, you should not take it as an indication of any view we've formed of the submission that you were just making. And we'll be a short break and we'll come back as soon as we can.
I'm very grateful. There's just one other matter of housekeeping. in terms of authorities. The first is some authorities passed up by the embassy. They were taken down by Mr. Legg's clerks to court yesterday, and I just wanted to check they had made their way into your authorities bundle.
I know some things were added to my bundle. Do you want to?
There's just a few right at the end, or almost at the end.
Yeah, so there are two categories.
Lady Fox's article had been
Yes,
truncated, and there were a couple of others. Right.
I've got things with clips on, so that's likely to be.
It looks as if the embassy's authority has been added. I, this morning, have passed up 3 further authorities, which your lordship's clerks have very kindly placed at the back of your volume 4.
Let's just have a look. So it's a Manchester police case, is it?
Yes, you should have in the last 3 in your volume 4.
I've got Re B.
Yes.
Well, it's good to see a family case coming into these.
Yes, my lord.
IBM against Dalgleish and the Chief Constable of Manchester.
Yes. I apologise for the late hand up, and you now have everything that your lordship should
Yep,
have.
you've got those.
Yes.
Yep. Yep. Good. Thank you.
Thank you very much. I have no further matters of housekeeping. Is there anything else I can help your lordships with on that?
No, thank you.
So, starting off with the relevant context of the instant appeals. This is an appeal arising out of an employment tribunal claim brought by the claimant. I'll refer to Miss Aliahi as the claimant and as the respondent to the embassy, the respondent in those first instance proceedings as the embassy. Materially, for the purpose of the instant claim appeal, the claimant's original employment tribunal claim was a combination of claims. Some claims derived from the EU law, most obviously discrimination claims under the Equality Act, and some other claims which were not derived from EU law. Moving on with the relevant factual context, there was a case management hearing before the Employment Tribunal on the 19th of March 2019. And at that point, the employment judge at that hearing drew the embassy's attention to the Supreme Court case of Ben Carbushi and the Embassy of the Republic of Sudan. And I will come on to the proper meaning of the Ben Carbushi case, but I don't think there's any dispute between the parties that as of 19th of March 2019, the current state of the law was that the ET, the Employment Tribunal, had jurisdiction over employment tribunal claims derived from EU law, provided that that claim did not arise out of inherently governmental act. Now, on the 19th of April 2019, the solicitors firm then representing the embassy wrote to the Employment Tribunal, and it's useful, I think, to look at the terms of that correspondence just at this stage, and that's at paragraph 24 of the Employment Tribunal judgment, which you will find on page 188 of the core bundle. So, partner at Howard Kennedy, the firm then representing the embassy, wrote to the tribunal in the following terms. We confirm the respondent does not consider it necessary to amend the grounds of resistance, but accepts the tribunal has jurisdiction over claims which are derived from EU law. Now, following that concession, back over the page on page 187 of the core, paragraph 9 of the tribunal's judgment, the claimant withdrew her domestic law claims, the claims of unfair dismissal, unlawful deductions from wages, and breach of contract. So following the embassy solicitor's concession, the claim as it proceeded were only claims deriving from EU law. Now, from that point, from April 2019, the claim was progressed with substantive involvement from the solicitors from both parties. And I take you, again, in the Employment Tribunal judgment, page 189 of the core, starting, please, at paragraph 26 of that judgment.
Sorry, I missed the page.
Page 189 of the core, my lord,
Thank you. Yes,
starting at paragraph 26. we have the tribunal's detailed account of the progression of the case by both the claimant solicitors but by the respondent solicitors. The respondent is here the embassy. Substantial steps taken in the proceedings. Over the page, please, page 190 of the code. We come to the 4th of April 2021, in the region of 2 years later, after substantial progression of the case. On 4th of August 2021, the embassy solicitors, still on record as the embassy solicitors, made an application that the final hearing be vacated. And the application said, our client is reasserting state immunity in these proceedings, and we are instructed to engage for this purpose only. Now that is what led to the hearing before Employment Judge Brown on the 30th of November 2021, which gave rise to the Employment Tribunal judgment, which is the subject of this appeal. And at that hearing before Employment Judge Brown, the Employment Tribunal asked 3 questions. Did the Employment Tribunal have jurisdiction by reason of the embassy having waived immunity? And that is the decision that gives rise to ground 1 of my appeal. The second question was whether, even if the embassy had not waived immunity, the embassy in any case had no immunity following the decision in Ben Carbushi, because this was not a claim arising out of inherently governmental acts. Now, by the time, although that was argued on various bases below, by the time that matter reached the EAT, the Employment Appeal Tribunal, the sole basis upon which the EAT considered that matter was whether the claimant's claim arose out of inherently governmental act by reason of the claimant's job functions. And that is the decision of the Employment Tribunal, which gives grounds 2 and 3 of my appeal. The third question asked by the ET at that hearing before Employment Judge Brown was, even if the embassy would have been immune because it had not waived immunity, and even if the embassy would have been immune because the claim arose out of inherently governmental acts, the Employment Tribunal nevertheless had jurisdiction insofar as the claimant's claim was a personal injury claim. And that is the point under Section 5 of the State Immunity Act, which is ground 1 of the embassy's appeal.
Yes.
I'd like to start, if I may, by taking through the statutory provisions. You will have seen from the party skeletons that the legislation has been subject to a remedial order,
Yes.
which has some retrospective effect. I'll say at the outset that the parties are agreed, and there is now Supreme Court authority to the effect that for the purposes of the issue in this case, the effect of the remedial order has no material effect on the test that needs to be applied. So I will take you, if I may, when introducing the statutory provisions, to those as they were at the date of the Employment Tribunal decision, because those, of course, are the provisions which the Employment Tribunal applied.
Was that tab 3?
Tab 3, yes, within your volume 1. So, Section 1 of the State Immunity Act sets out the general immunity from jurisdiction. The state is immune from the jurisdiction of the courts of the United Kingdom except as provided for in the following provisions of this part of the Act. And we have, and I draw your attention because both parties will come back to it, the provision at Section 1(2). A court shall give effect to the immunity conferred by this section, even though the state does not appear in the proceedings in question. The court's duty to give positive effect to state immunity. Turning next, materially, for the issues in this case, we have Section 2, submissions of the jurisdiction. Section 2.1, a state is not immune as respect proceedings in respect of which it has submitted to the jurisdiction of the courts of the United Kingdom. So section 2.1 provides that a court may submit. Now, I don't think there's any dispute that submission may be explicit, but we also have at section 2.3 circumstances in which a state will deem to have submitted. This, and materially, for the purposes of the instant appeal, a state is deemed to have submitted, subject to subsections 4 and 5, which I don't think are of relevance here, if it has intervened or taken any step in the proceedings. Now, section 2.7 is a further deeming provision, designed, I suggest, to resolve any ambiguity about what it means to submit and who has authority to submit. Section 2.7 of the State Immunity Act: the head of the state's diplomatic mission in the United Kingdom, or for the person for the time being performing his functions, shall be deemed to have authority to submit on behalf of the state in respect of any proceedings. That's the material part for the purposes of this appeal.
Just looking at the wording of subsection 1, state not immune, in respect to which it has submitted. That,
yes.
On one reading, suggests that it's an act, and once the act has been undertaken, the provision is triggered.
Yes, and I don't think there is any dispute between the parties that the Howard Kennedy email of 2019 would have fallen within the ambit of section 2.1. The dispute is whether it was authorised by the relevant person within the meaning of section 2.7.
Right.
So I don't think there is any dispute that the Howard Kennedy email, had it been authorised, which is, I say, is an issue of fact by the head of mission, was a submission to the jurisdiction under section 2.1. What was in dispute before the employment tribunal was the factual question whether, when Howard Kennedy wrote that email, it was authorised by the relevant person and therefore was a proper submission to the jurisdiction.
But in any event, subsection 3 says the state is deemed to have submitted if it's intervened or taken any step in the proceedings.
It does, and the way
it's one thing to look at an email, it's another to look at what they did for the following 2.5 years.
Yes, and again, I don't think there is any dispute, and there was no dispute before the ET, that had that substantive engagement in the case been authorised by the head of mission, it would have constituted a submission to the jurisdiction under section 2.3.
Yeah.
The dispute between the parties before the ET was not whether that conduct would, if authorised by the correct person, fall within the ambit of section 2. The dispute was on a pure factual question as whether it was authorised by the head of mission or the person for the time being performing his functions.
Yeah. Okay.
Just staying on the statutory provisions while they are open, and having a look, please, my lords, at section 4, contracts of employment. This is an exception to the general provision of immunity. A state is not immune as respect proceedings relating to a contract of employment between the state and the individual, where the contract was made in the United Kingdom or the work is to be wholly or partly performed there. And I'll draw your attention, if I may, your lordships, to section 4.6. In this section, proceedings relating to a contract of employment includes proceedings between the parties to such a contract in respect of any statutory rights or duties to which they are entitled or subject as employer and employee. So in this case, the claimant's case was a claim under various pieces of statutory employment legislation, statutory torts. They were statutory rights or duties to which they are entitled as employee and employee. That was the provision of section 4. Staying on this page while we are here, on page 26 at the bottom, section 5, a state is not immune as respect proceedings in respect of A, death or personal injury, or B, damage to or loss of tangible property caused by an act or omission in the United Kingdom. So that, Ms. Aliahi says, is another free-handing exception about the type of damage, death or personal injury. And turning, please, if I may, to section 16 of the State Immunity Act, as it was at the date of the Employment Tribunal hearing, on page 32 of the Authorities Bundle. Section 6 disapplies Section 4 in relation to contracts of employment, does not apply to proceedings concerning the employment of members of the Commission, and this is the provision which is disapplied under the Ben Carbushi judgment in respect of claims which do not arise from an inherently sovereign act. And I pause to note, while we're doing this general review of the legislation, that Section 16.1 disapplies Section 4, it does not disapply Section 5. So that was what I wanted to say in terms of general statutory overview. Turning, if I may, to my ground one. And ground one is in relation to the issue of waiver. The Employment Tribunal found that the embassy had submitted to the jurisdiction. As I said, there was no dispute before the ET that the Howard Kennedy email would, had it been authorised by the head of mission or the person for the time being performing his functions, have constituted a submission. And there was no dispute before the ET that the substantive involvement on behalf of the embassy taking steps in the proceedings would have been deemed to be a submission had it been authorised by the head of mission or the person for the time being performing his functions. It's important, I think, at this point to look at the case law on the proper role of the ET when faced with a dispute like this, whether or not the head of mission had in fact authorised submission. And the leading case on this is a case called Republic of Yemen and Aziz. It's in volume 1 of your Authorities Bundle, behind tab 17, page 228, if anyone finds it easier to use page numbers. This is a case in which an embassy employer had entered an appearance in employment tribunal proceedings. It was a case of deemed submission under section 2.3b of the Act. And if I could pick it up, please, on page 1406 of the internal numbering, little f down the side.
Sorry, give me the paragraph number.
F, my lord.
All right, then page.
It's 1406 of the internal numbering, 243 of the Authorities Bundle.
242.
243, my lord.
243. Thank you.
And just above paragraph F, dealing with section 2.7, the authority says, by deeming the existence of authority in the head of mission, the statute has clarified a point which may previously been uncertain, though it does not follow that there is no other way a state can submit to the jurisdiction, that is common ground. However, if it is to be a step by the state in the proceedings, as contemplated in section 2.3b, action taken by a member of the diplomatic mission must, in my view, be taken with the authority of the head of mission or the person for the time being performing his or her functions. The head of mission has deemed authority to submit under section 2.7, and that includes authority to delegate, in my view. And then 2 lines above little number H, the head of mission may confer authority on a member of his mission or a solicitor instructed by the mission. I do not accept that. For the purposes of section 2.3, he could do so only on the specific instruction of his government. that would be to delegate from the authority which Section 2 deems him to have. The relevant action need not be taken personally by the head of mission. He or she needs only have authorised it. Over the page, please, page 244, paragraph 56. This is the authority to the effect that the fact that a step was taken by solicitors instructed by the embassy does not conclude the matter. 4 lines in, a solicitor without authority cannot waive the immunity. The solicitor's actions establish a waiver only if they have been authorised by the state, which includes authority exercised or conferred by the state's head of mission. And then paragraph 58 on that page, page 240 all. I do not consider that the doctrine of ostensible authority applies either to the solicitors or to Mr. Alcanda. Mr. Alcada was somebody employed by the mission but not the head of mission, or that jurisdiction can be created by an estoppel. So the employers were entitled in the circumstances to assert before the appeal tribunal that there had been no waiver of immunity and hence no jurisdiction because the earlier steps in the proceedings were not taken by the state. So this is a case in which the Republic of Yemen took an analogous point to the embassy in this case. Notwithstanding steps taken in proceedings, they said, as a matter of fact, that was not authorised by the head of mission. But what that does not mean, and this is important, and I say this is established by as is that that does not mean that the employment tribunal need necessarily take the embassy at its word. Indeed, the question of whether or not the head of mission or someone for the time being exercising his functions has authorised submission is a question of fact for the employment tribunal. And staying please on paragraph 58 of as is, just 2 lines above number E in the margin. As already noted, it is necessary to determine the factual issues arising in order to decide whether there has been a waiver under section 2. It is open to the tribunal to do this by inference. It would be open to the fact-finding tribunal to infer from all the circumstances that Mr. Alcada was acting with the authority of the head of mission. If that happens, the state has taken the steps and is deemed to have submitted. The same process of reasoning applies to steps taken after the employment tribunal's decision as to jurisdiction, as to steps taken before the decision. The court is entitled to expect that a state which does not wish to have its authorisation procedures inquired into by the fact-finding tribunal will put in place readily ascertainable procedures for waiver. And while I am on as is, if I could please go back to paragraph 41 of that authority, which is page 239 of the authority bundle. Now, it refers here to a 1957 case called Bacchus, which I'm afraid is not in the authorities bundle. I admit that I thought it was before the EAT, but the passages I intend to take you to are within this authority. So I have a copy, but I don't intend to pass it up. This is a case in which the defendant organisation participated in proceedings before it sought to contend that the defendant was in fact a department of the Spanish Ministry of Agriculture. And it's important to bear in mind that this case predates the Section 27 deeming procedure. It predates statutory provision dealing with who should be deemed to have authority to submit on the part of the head of mission. And it was alleged that the Spanish government could not have submitted unless it had in fact been authorised by the foreign sovereign. But what I want to take you to is the extract quoted at paragraph 45 of this is on page 241 of the authorities article. Now this is a case in which the Court of Appeal determined that it was in principle possible for a foreign sovereign, for a state in a modern language, to say that they had not properly submitted because the authorization had not been given by the correct person. And I want to take you, please, to the part of Lord Justice Parker's speech, which starts 3 lines above little number d in the margin on page 241. It is true this does open up the rather alarming prospect that a foreign sovereign may allow proceedings to continue for years in this country before taking the point that submission had not been authorised by the relevant person. But for my part, I think that that is a theoretical difficulty. I do not think that any person, even though he be a foreign sovereign, and I suggest here that that is simply a comment as to the sort of credibility on normal evidential terms that might be given by a court to an embassy who is in the best position to say what they have and have not done, would be likely to be believed if in such an extreme case he were to come forward and assert that he had no knowledge whatsoever of the proceedings. So far, however, as this case is concerned, I am satisfied that the point has been properly taken and that there has been no waiver. So, the question for the Employment Tribunal was a factual one. Has the head of mission, the person for the time being performing his functions, authorised submission? And the authorities make it clear that that is a question of fact for the tribunal, and they make it clear that that is a question that, as with any other question of fact, can, in appropriate cases, be determined by inference. With that in mind, I'd like to take you, if your lordships, if I may, to the Employment Tribunal's judgment on this point. That is in the core bundle. Page 199 of the core bundle, please. And I say that the key findings of fact are at paragraphs 114 and in particular at paragraph 115 of the Employment Tribunal judgment. I decide that the respondent submitted to the jurisdiction in respect of the claimant's EU-derived, law-derived claims, and that the head of mission or his deputy authorised this. Looking above that, at paragraph 113 of that judgment, the Employment Tribunal was conscious that in making this finding, it was drawing an inference. It is open to the tribunal in determining that issue to infer from all the circumstances that a member of the mission or solicitors instructed by the mission acted with the necessary authority. And it drew that inference only after making detailed findings of fact and conducting a thorough analysis of those detailed findings of fact. Now, the only evidence which the embassy called in relation to what I'm going to tell on the waiver point was from a Mr. Blasey. You'll see paragraph 49 of the Employment Tribunal judgment, which appears on page 190 of the core. Miss Trabelsi's job as a student compliance advisor involves providing support and advice to students from Saudi Arabia who are studying or hoping to study in the United Kingdom. The embassy did not call the head of mission. It did not call anyone authorising carrying out the functions of the head of mission. And looking, if I may, at the Employment Tribunal's findings of fact, the Employment Tribunal noted, page 191 of the core, paragraph 61, that the Howard Kennedy file, the file of the then instructing solicitors, was not disclosed. The embassy disclosed some correspondence, but the Employment Tribunal found that this did not constitute the full file, and in particular that the embassy had not been provided initial instructions and who had given instructions. Significantly, on the 19th of March 2019, the Employment Tribunal had drawn the embassy's legal representative's attention to the Ben Carbushi case and asked the embassy's position. Paragraph 62 of the judgment, page 192 of the core, Miss Murray Hind, who is the partner at Howard Kennedy, then acting for the embassy, emailed Mr. Basin, and these are the tribunal's findings of fact. And this email was before the Employment Tribunal. In short, we need to confirm the following. 1, whether we wish to file an amended response in relation to the jurisdictional points and or the cultural bureaus standing within the embassy. My view is we do not need to do so, and we can simply confirm this. And secondly, a point about mediation. And then at paragraph 64 of the judgment, the Employment Tribunal found that Mr. Abelsi nevertheless replied, "We agree with your point 1 and 2, so please go ahead." Looking forward at paragraphs 65 and 66 of the Employment Tribunal judgment on page 192, you have the Employment Tribunal recounts Mr. Abelsi's evidence that she said that Miss Murray Hind had not explained to Mr. Abelsi the legal implications about submission to the jurisdiction. And Mr. Abelsi said she did not know what this meant. And you have the Employment Tribunal's judge's findings at paragraph 66. I find Mr. Abelsi's evidence to be unreliable regarding the emails of the 8th and 9th of April and regarding Mr. Abelsi's role in providing instructions to Miss Murray Hind. You have a look at page 69 of the Employment Tribunal judgment, page 192 of the core. The Employment Tribunal found that it was clear that Miss Murray Hind had previously given legal advice about mediation and had discussed the distinction between discrimination and other claims. That is, in general terms, the EU-derived, law-derived claims and other claims. She refers back to Miss Murray Hind's email quoted at paragraph 62. At this time, we do not know whether any of the claimants will stay their claims or opt to pursue only discrimination ones. And the Employment Tribunal's findings of fact, and that Miss Murray Hind understood that Mr. Abelsi was aware of this.
So there were other claims by other claimants?
Yes, so the email, which was before the Employment Tribunal, there were other claims by other claimants. They were not joined in the same proceedings, but Miss Murray Hind's email is communication with Mr. Abelsi about more than one claim against the embassy.
Yeah, so it was a bigger issue, potentially, for the embassy than just the one claim.
There were other Employment Tribunal claims, and it is obvious from the email, which of course is all up, that Miss Murray Hind was advising her not just about one claim, but about other claims as well.
Yeah.
And then you have the Employment Tribunal's observation of paragraph 70, page 192. Mr. Abelsi's evidence was wholly at odds with this, but it was noticeable that Mr. Abelsi never questioned Miss Murray Hind's understanding, whether in Mr. Abelsi's immediate reply or at any point thereafter. Then you have the Employment Tribunal's comment at paragraph 71. In her reply, Mr. Abelsi said, "We agree with your point 1 and 2. I considered that it was notable that Mr. Abelsi, who told the tribunal that she speaks English and Arabic, used the word we and not I. Her own words indicated that she was not simply speaking on her own behalf." We then move on to paragraph 72, page 193. On 9th of April 2019, Miss Murray Hind wrote to Mr. Tribulsi, copying in somebody else, Mr. Al-Alim. She said, "Thank you for confirming your instructions yesterday. I have this morning emailed the tribunal in each of the 4 claims to confirm that 1, the Cultural Bureau accepts the claimants can pursue claims deriving from EU law." And then the finding of paragraph 73, Mr. Tribulsi did not reply, questioning Miss Murray Hind's email. And then key finding at paragraph 74, I considered that Miss Murray Hind had made it clear that she considered that Mr. Tribulsi had given instructions and that the respondent had accepted that the claimants could not pursue EU law-derived claims. Her email was in clear terms. I did not accept Mr. Tribulsi's evidence that she never gave instructions and that she did not understand the legal implications of the instructions she gave. Now, staying with the Employment Tribunal's judgment, it's important to note that at the stage at which the Employment Tribunal reviews the evidence, my lord, we have paragraph 82, page 193. For the purpose of the open preliminary hearing, I was provided with a statement which was not signed by any individual but was stamped with an embassy stamp. And I should say this is the statement that was simply exchanged with witness statements at the point at which witness statements were exchanged for the purposes of this hearing. And you'll see at the top of page 194 of the core that the contents of that statement are extracted in full. And given the part that this statement plays in this appeal, it's perhaps helpful to turn it up. The statement itself appears on page 3 of the supplementary bundle. It is a statement, I will refer to it, if I may, as the unsigned statement, simply because that is how the EAT, the judgment below, refers to it. It is on embassy-headed letting paper. It is not prepared in the name of an individual. It is stamped with an embassy stamp. There is nothing to suggest that it has been prepared by solicitors on instructions. And it simply restates the embassy's case that neither the ambassador nor anyone working on his behalf has authorised Ms. Tribulsi.
And the date, and I think you've alluded to this, the date is the 24th of November 2021, and I note the Employment Tribunal hearing started on the 30th. So
yes, I can check the date on which witness statements were exchanged, but I do remember it was relatively shortly before the hearing.
It's generated for the hearing is the implication, rather than something that was in a wider consideration of these issues.
That would be my submission on it, my lord. Yeah. It's exchanged with witness statements and addresses the embassy's case.
Miss Darwin's helpfully nodding.
And going back to paragraph 82 of the Employment Tribunal judgment, page 193, it is obvious that the Employment Tribunal notices the pertinent qualities of this document. It was not signed by any individual, but was stamped with an embassy stamp. Now, having made those very detailed findings of fact on the basis of the evidence which the embassy chose to provide for the purpose of these proceedings, the Employment Tribunal then properly analysed that evidence. And if I could pick this up, please, at page 197 of the core. Paragraph 101 of the Employment Tribunal's judgment, the finding, the analysis there by the Employment Tribunal, I concluded that the evidence about the respondent's instructions to Howard Kennedy in this case was both partial and unsatisfactory.
Ms. Stanley, just before we move on, 99 is important, isn't it? Because the Employment Tribunal judge had in mind and sets out the respondent's case which, as you say, was as per the unsigned statement.
Yes, my lord. That.
So that's the starting point.
The starting.
And then the judge then goes on to deal with the specific evidence relating to this case between 100 and 115.
Indeed, my lord, and your lordship will see at paragraph 102, in considering why the evidence was both partial and unsatisfactory, there is a careful consideration of the evidence, and you'll see in considering the evidence at the end of paragraph 102, I had an unsigned statement from the Saudi embassy. So I would agree with your lordship. Paragraph 99 incorporates the embassy's case as per the unsigned statement, albeit the content of the unsigned statement was really the respondent's case as a whole before the employment tribunal at this hearing, and it's referenced again at paragraph 102 of the judgment when running through the evidence. Over the page 198 of the call, turning to the oral evidence, paragraph 104, the employment judge notes that Miss Trebelsey was the only witness regarding any authority given to Howard Kennedy solicitors to submit to the jurisdiction. She denied that she had given any instructions to Howard Kennedy to do so. She said she had not been given authority by anyone in the embassy, including the ambassador and his deputy. But paragraph 105, Miss Trebelsey's evidence was not credible. That is an analysis by the first instance judge as to the credibility of the evidence heard. That credibility was assessed not simply by nature of the evidence that Miss Trebelsey gave, but to the plausibility of her evidence. Paragraph 106. The Employment Tribunal found in its analysis it was inconceivable that such a junior employee would have taken it upon themselves to make such decisions about the conduct of the proceedings without seeking authority to do so. Such conduct would have been inexplicably reckless. Similar points made at paragraph 108. 107, the employment judge refers back to the use of we and not I. And then analysis by the Employment Tribunal, not necessarily dependent on the content of Miss Trebelsey's evidence. Paragraph 109. I also found it very difficult to believe that an experienced employment law solicitor would act in state immunity proceedings without establishing that the person who was giving instructions had proper authority to do so. So the employment judge entirely permissibly takes into account that as a partner to a reputable law firm, she cannot believe she would not have checked that she was taking instructions from the appropriate person. Paragraph 110 noted that she does not have the complete picture and the file was not available. So those are the Employment Tribunal's findings of fact. That is the careful analysis of the Employment Tribunal, and in those circumstances, the Employment Tribunal draws the inference and makes the key finding of fact that the respondent submitted to the jurisdiction and that the head of mission or his deputy authorised this. In terms of the embassy's challenge to that finding on appeal, it's worth taking a little bit of time to see how this litigation has developed, if I may. So if I could ask your lordships to turn up, please, page 176 of the call. Now, these are the embassy's original grounds of appeal to the EAT at permission stage. And ground one was the ET erred in failing to take into account the official stamped statement. But I'd like to draw your attention that at permission stage in the EAT, the embassy sought to run a far wider challenge to the employment tribunal's finding of fact that the head of mission had authorised submission. It was not permissible for the employment tribunal to draw, in the embassy's terms, the far-fetched inferences. It sought to run a much wider diversity challenge. And if I could ask you, please, to have a look at, it's in the supplementary bundle, I'm afraid, page 62. These are the reasons at permission stage that Mrs. Justice Eadie gave the embassy for permitting the embassy's appeal to proceed before the EAT. The only ground which Mrs. Justice Eadie permitted to proceed before the EAT in relation to the waiver point was ground 1. It is contended that the ET erred in failing to consider, give weight to the official stamped statement. That's the language used by the embassy for the unsigned statement, given the potential nature of the document in question. I was prepared to permit this point to proceed to full hearing, although the weight to be given to any piece of evidence must be a matter for the ET. There is a question as to whether the ET took proper account of the nature of this particular document. And just for completeness, if your lordships could turn up page 181 of the core.
Round two goes. Yep.
This is the ground of appeal as it proceeded before the EAT on the part of the embassy. The ET erred in failing to take into account the official stamp statement from the embassy and or give it any weight. Now, turning to the way the embassy dealt with this before the EAT. The embassy before the EAT sought to argue that there were various authorities suggesting that a document of the nature of the unsigned statement had a particular nature, had a particular weight. And I say, simply so you can read the Employment Tribunal judgment and the EAT judgment together, that none of these authorities, which were said to go to the particular nature of the unsigned statement, were cited before the Employment Tribunal. They were cited for the first time before the EAT. Now, in terms of the EAT's judgment on this point, the EAT's judgment, I say, is encapsulated in 3 paragraphs of Mr. Justice Bourne's judgment. If your lordships could go to page 157 of the call. Mr. Justice Bourne said, in my judgment, the difficulty is that the employment judge did not appear to give the certificate or unsigned statement any weight at all. At any rate, nothing in her reasons enabled me to identify the weight it was given. And that needs to be read, I say, with paragraph 74, that's page 158 of the call. I agree with Miss Darwin that when the question came to be answered, it was necessary to give some weight to the unsigned statement. That is not to accord any special status to such a statement, but merely to recognise that it was put forward by an embassy as an official document and that its contents ran directly contrary to the employment judge's inferences. And then paragraph 76, nevertheless, I conclude that the employment judge erred in law by not giving any weight or any perceptible weight to the unsigned statement. So, in seeking to identify the ratio of the EAT's decision, what I say is that the EAT rejects the contention, this is my primary case, that the unsigned statement document had any particular nature or status, that there was any rule of evidence that meant it should be given particular weight, but that the EAT said that the Employment Tribunal had erred in law by not giving the unsigned statement any weight or particular weight. And to put my case in this appeal in a nutshell, I say that this is an impermissible approach to take on appeal. It is interfering with the weight to be given to evidence, which is a matter for the first instance fact-finding tribunal.
Do you accept that if this had been a statement signed by the ambassador personally, or perhaps signed by the then ambassador personally, that would have been the end of the case? It seems to me very odd that it should that anything should turn on the difference between a stamped statement and a signed statement.
No, my lord, I don't. Had it been a witness statement from the ambassador, had it been if there is a difference between a certificate and a witness statement where someone does not turn up to give evidence, it's not clear to me. But had it been a document in the name of an ambassador or a witness statement from the ambassador, I don't in any sense say that would be determinative. That would be evidence. It would need to be weighed by the first instance judge. The Employment Tribunal, following as is, would need to make a factual determination as to whether or not the ambassador had authorised submission. It is absolutely open to the Employment Tribunal not to accept the evidence of an ambassador, whether given by way of a document or whether given by way of a witness statement, that if he says, I haven't authorised it, the Employment Tribunal may very well not accept that evidence. And I don't accept that there is any particular special status or weight that attaches to evidence given, either by an embassy or indeed by an ambassador personally, beyond the fact that on normal evidential principles, if the factual question is, did an ambassador authorise X, that ambassador is going to be in a very good position to answer that question. And so on entirely normal evidential principles, the person who is alleged to have done something may be thought to give credible evidence about whether or not he has done it. But in all sorts of first instance proceedings, first instance judges do not accept people's evidence, and it is absolutely open, I say, to an employment tribunal not to accept the evidence of an ambassador.
But do you accept the premise that if he had produced a statement and it was true, that he had not in fact expressly authorised the waiver, the critical email of April 2019, that would be the end of the case? In other words, Ms. Darwin's case, I think, is that it's open to a state to take this point at any stage, even after the litigation has been running for years, that this was never authorised, that the solicitors in fact had no authority from the head of mission or deputy head of mission, and therefore the case should never have been allowed to get this far, and that's the end of it.
I accept that if the Employment Tribunal had found as a fact that he had not authorised it, then yes, the state would not be taken to have waived jurisdiction. That's the effect of the Aziz case. But the Employment Tribunal would have to find that as a fact. I do not accept that there should be any particular deference to that evidence. It's a factual matter for the tribunal.
Well, speaking only for myself, I find that very surprising. That if that's what the Aziz case says, it seems to me to be astonishing.
I mean, my lord, I would not say that it is open to a state to take this at any step of the proceedings. There is some case law where employment tribunals have, and I'm aware of it in the employment tribunal context, there may be case law in other contexts as well, where an employment tribunal has effectively said it is too late to take the point, it should have been taken earlier. But in Aziz, the point was taken and it was allowed to be taken for the first time on appeal at EAT after there had been a first instance determination. And Employment Judge Brown in London Central allowed the embassy to take this point. We didn't appeal that decision. It's a question of fact for her whether or not the head of mission has authorised it, or someone carrying out his functions, I accept that if she had found as a fact that he did not, there would have been no waiver. The Employment Tribunal might well have had jurisdiction on another basis, if following the Ben Carbushi principle, regardless of whether or not there had been a waiver.
Yes.
But your case on this point is really back to first principles in relation to any fact-finding judgment. Your submission is that it just was impermissible for the Employment Appeal Tribunal to interfere with the finding of fact on this basis. Looking at that, if the Employment Tribunal had completely ignored the certified statement, do you accept that on appeal, the Appeal Tribunal could have said there was incorrect fact-finding exercise, crucial evidence was ignored, we've got to set it aside?
No, my lord, I don't.
Right.
There is a principle that a first instance fact-finding tribunal, and I do not think this is specific to the Employment Tribunal, these are normal fact-finding principles, must take all relevant evidence into account, but it is also well established that a judgment need not refer to each and every piece of evidence. The case that we normally refer to in an employment context, simply because I think it is an Employment Tribunal case originally, is DPP in Greenberg. I was going to come to it later, but maybe we'll go to it now. It's in volume 3 of your authorities, please.
Tab 34.
Yes. So this is a case about reasons, about sufficiency of reasons, and it is usually cited in that context. But the key paragraph is paragraph 57 on page 783 of the authorities bundle. And these are, as I say, normal principles about the proper reading of a first instance judgment. Paragraph 57.2, the tribunal is not required to identify all the evidence relied on in reaching its conclusions of fact. To impose that such a requirement would put an intolerable burden on the fact finder. And then in the other column, little paragraph 3, it follows from 2 that it is not legitimate for an appellate court or tribunal to reason that a failure by an employment tribunal to refer to evidence means that it did not exist, or that a failure to refer to it means that it was not taken into account.
So your submission is that the EAT took far too puritanical a view of the approach below, and the fact that there was no reference in the weighing up of evidence of the certificate to indicate what weight was given to it doesn't mean that it wasn't taken into account. Clearly the ET judge knew of the certificate because she refers to it, and her analysis, which points to the fact that notwithstanding the certificate, neither the head of commission or head of mission or the deputy were called, the file wasn't disclosed, indicates that she was considering other factors alongside the certificate.
I'm not sure with respect, my lord, I would say the EAT took too puritanical a view. I think I would suggest that the criticisms were not legitimate ones of the Employment Tribunal judgment. The Employment Tribunal judgment makes reference not only to the unsigned statement, but to its pertinent qualities, and does refer to it when weighing up the evidence. My submission is, even if it had not done so, it's very clear from the authority that failure to refer to something does not mean it has not been taken into account, and the appellate court should assume, unless there is a very good reason otherwise, that first instance tribunals had in mind all the relevant facts when coming to a factual, when making a finding of fact. Turning to the proper approach beyond that with dealing with findings of fact, I did just want to take you to one case on that in a minute, It's in volume 2 of your volume. I think you should still have open. Behind tab 25. So this is the Supreme Court judgment on the proper approach to the appellate approach to first instance findings of fact. And your lordships note the relevant factual finding here, it's paragraph 5 of the judgment, page 483, is whether the sale of a particular piece of property had been sold for adequate consideration. It's a Scottish case, and the Inner House had allowed an appeal essentially on the finding of fact. The Supreme Court allowed an appeal against that judgment. And I wanted to just take you to two key passages. Page 497 of the authority. Paragraph 57 of Lord Reed's judgment. The trial judge must, of course, consider all the material evidence, although, as I have explained, it need not all be discussed in his judgment. The weight which he gives to it is, however, preeminently a matter for him, subject only to the requirement, as I shall shortly explain, that his findings be such as might reasonably be made. An appellate court could therefore set aside a judgment on the basis that the judge failed to give evidence a balanced consideration only if the judge's conclusion was rationally insupportable. And in terms of what rationally insupportable means, your lordships were to have a look at page 498 of the authorities bundle, paragraph 62. Given that the extra division correctly identified that an appellate court can interfere where it is satisfied that the trial judge has gone plainly wrong and considered the criterion was met in the present case, there may be some value in considering the meaning of that phrase. The adverb plainly does not refer to the degree of confidence felt by the appellate judge that it would not have reached the same conclusion. And then the end of that paragraph, what matters is whether the decision under appeal is one that no reasonable judge could have reached. So that, I say, is the standard of perversity in challenging a factual finding. And I don't suggest, my lord, that there is anything novel or new here.
Thank you.
Going back, if I may, to the EAT's judgment on this point, the EAT says paragraph 76 on page 158 of the EAT judgment, I conclude the employment judge erred in law by not giving any weight or any perceptible weight to the unsigned statement. The appellate court assumes, following Greenberg, that all evidence was taken into account. In this case, the evidence was mentioned and its pertinent qualities noted. The weight to be given is a matter for the first instance tribunal. And I would say it is, of course, open. I don't suggest that this is a proper or a fair reading of the employment tribunal's judgment, but it is, of course, open to a first instance tribunal to give a particular piece of evidence no weight. That is a balancing act for the first instance tribunal.
So where does that finding leave? Paragraph 76, I conclude they erred in law, not giving any weight to the unsigned statement. Where I've looked through the EAT judgment further on, to find the consequence of that finding. And it may be that the subsequent findings or subsequent conclusions overtook events.
No, that is on that basis, on the basis of that finding, on ground one, that the employment judge erred in law, we have the order, which appears page 169.
Thank you.
I apologise, page 137 of the core, paragraph 1.
Thank you. Right, that's helpful. I haven't seen that.
Ground
Sorry,
one.
which page, Mr. Stanley?
I apologise, my lord, page 137.
137.
137.
137 of the core. So there are two orders of Mr. Justice Bourne arising out of his judgment, but the only order arriving out of the waiver ground is paragraph 1 on page 137. Ground 1 of the appeal is allowed. The finding that the appellant submitted to the jurisdiction of the courts of the United Kingdom and or waived its immunity from the jurisdiction of the courts is set aside.
Yeah.
Unless further agreement can be reached between the parties in the meantime, the question of submission waiver is remitted to the Central London Employment Tribunal to be decided by a different employment judge.
Right.
So what I am asking your lordships to do, by way of this appeal, is to set aside paragraph 1 of that order. I say that order was made solely on the basis that the EAT considered that no weight or no perceptible weight had been given to the unsigned statement, but that was not a reason for the Employment Appeal Tribunal properly to overturn the ET's decision, and that therefore this order, paragraph 1 on page 137, should be set aside.
So without more, that issue, if we do nothing, and if we reject your appeal on this ground, there's the potential for it to go back to square one at the Employment Tribunal.
Yes.
However, it may be that if either party succeeds on other parts of this, that it's academic and it wouldn't be pursued, but it's the potential for it to go back to square one is there.
I agree, my lord. If I lose on both of my grounds of appeal, the position about ground 2 and Miss Darwin is successful on ground 1,
yeah,
that will mean, in my submission, that this will simply go back for remission on the waiver point before the Employment Tribunal, obviously.
Yeah. Well, we'll see
we
when
would
we get
very
to
much prefer not to be in that position.
Yeah.
And the consequence of that would be that a decision, suppose that the ET on remission decided that there had been a waiver, that decision could be appealed to the EAT and with permission to this court before any hearing on the merits. So it might be another 2 or 3 years
Indeed, my
before
lord.
there was a hearing on the merits.
Indeed, my lord.
Right. Right. So here we are at 11:45.
Oh, yeah.
No.
I'd like to deal briefly, if I may, with just a few points that the embassy make in
Yes.
their skeleton on this ground. If you have the embassy skeleton on there, paragraph 112.
Yes.
The embassy's ground. The embassy says, for the reasons explained by Mr. Justice Bourne, the official statement was highly material to the question of whether the embassy had submitted to the Employment Tribunal's restriction.
Now, are you reading from paragraph 12?
112, my lord.
Thank you.
What is indicative, I say, from the manner in which the embassy has dealt with this in the skeleton, is that it is suggested that the particular authorities which the embassy relied on before Mr. Justice Bourne, as going to the nature of the unsigned statement, in some way informed his conclusion on weight. Now, it is indicative, I say, that nowhere in the embassy skeleton do they extract from or cite those authorities, such as to put meat on the bone to suggest that those authorities had any material effect on Mr. Justice Bourne's decision on weight. The skeleton says the statement was highly material to the question. The statement might have been material or it might not have been. That is a question of weight, which, as I say, is a matter for the tribunal. Going on to what the embassy says of paragraph 113 of their skeleton. A trial judge must consider all the material evidence. However, this is particularly important in state immunity cases where a court or tribunal is subject to the duty of inquiry. Now that, I say, is to allied two very different issues. The duty of inquiry, section 1.2 of the State Immunity Act, is about the court giving effect to state immunity even if the state is not present. In that sense, it relaxes some of the normal principles of adversarial litigation. It can, in some circumstances, be used to mean that points not taken below can be taken on appeal. That was the position in Aziz, for example. Section 2.1 was held to mean, that's paragraph 51 of your Lordship's note of Aziz, page 242 of the authorities bundle. The positive duty to give effect can be held to mean that points not taken at first instance can be taken below. But the positive duty to give effect says nothing about weight. It says nothing to put a thumb on the scales to suggest that the embassy's evidence should be particularly material or particularly credible. The other circumstance in which section 2.1 has been used materially recently is there's been a very recent Supreme Court decision called Constantine in the Supreme Court. Again, I'm not going to take your Lordships to it unless you particularly want me to, but you'll find it behind tab 46 in volume 4 of your authorities, page 1182 of the bundle. And that was a case in which the embassy employer in that case did not appear in the Court of Appeal, and the Court of Appeal dismissed the appeal on the basis of non-appearance. And the Supreme Court held that positive duty meant that point that it should not have been dismissed for non-appearance in the Court of Appeal. What it does not do is say evidence on embassy-headed letter paper, or indeed a witness statement from the ambassador, has any particular evidential weight. And to suggest otherwise that paragraph 113 is to elide, I say, those two issues.
Yes.
That, I say, was my primary case, where I said that Mr. Justice Bourne did not find that the unsigned statement had any particular special nature, such as put a thumb on the scale. And that, I emphasise, is very much my primary case. I do want to deal very briefly, and your Lordships will see I've done this in my skeleton, in relation to what Mr. Justice Bourne says at paragraph 64 of his judgment. Paragraph 64 is page 157 of the report. And this, I say, is the closest, if the embassy were to submit, and it appears from their skeleton that they are not seeking to refer to any particular authorities, but this is the high point of the judgment in suggesting that any of these authorities might have anything pertinent to say about the weight to be given to this type of evidence. There's reference to a case called Krujina, paragraph 62, and reference to a case called J.S. Singham in paragraph 63. And Mr. Justice Bourne says at paragraph 64, it is, however, a second case after Krujina which refers to the possibility of a certificate providing the necessary evidence, and 2, approves the use of hearsay evidence to prove facts on behalf of a diplomat who considers it inappropriate to give evidence in person. And to just give you my headline points in relation to that paragraph, I say that I note the use by the EAT of the words "the necessary evidence." My position is that these authorities do not suggest that evidence given by a certificate, assuming a certificate is the equivalent document to the unsigned statement, has any particular status in relation to a factual determination of this type or at all. And I note the word by the EAT of the words "approves the use of hearsay evidence." I don't accept that these authorities suggest anything that hearsay evidence, either by way of witness statement or by way of a document analogous to the unsigned statement, has any particular status beyond the sort of status that would be given by normal evidential principles. And if it is said that paragraph 64, Mr. Justice Bourne's judgment suggests otherwise, I would not accept that.
But does this matter in fact? Because the judge has, on a flawed basis on your case, remitted it back to the first instance tribunal. So either the judge was wrong, if your ground one is right, either the judge was wrong to do that because he was wrong in what he said about the certificate. And if he was right, that will be a matter for the first instance tribunal.
I suppose, my lord, it is potentially relevant if it is said that part of Mr. Justice Bourne's reasoning, and to be clear, my primary case is that it isn't, but if it is said that part of Mr. Justice Bourne's reasoning is that there is something in these authorities that means that they should be given particular weight or particular relevance, such that the ET erred in not giving them that particular weight, that might be a point taken against me in terms of my primary submission, that this is all a matter of weight for the issue for the first instance tribunal.
Yes, although if that were right, one would expect to see it somewhere between 69 and 76, and one doesn't.
One would, my lord, and again, I having said this is, having made clear my primary case, but I will. It would also, seems to me, be inconsistent with what is said at paragraph 74. This is not to accord any special status.
Yeah.
Well, perhaps in those circumstances, I have dealt in my skeleton with what I say about those two particular authorities and why they cannot bear any particular weight of giving weight. My submissions on that point are at paragraphs 49 to paragraph 60 of my skeleton. I note that the embassy has not in its skeleton sought to engage with those authorities. If the embassy has anything to say in relation to what I say in my skeleton, I think I'd propose to deal with that in reply in those circumstances.
Yes, that's understood.
Dealing with that then, I should, I think, be able to turn to grounds 2 or 3 of my appeal.
Good.
So, starting with ground 2, and starting, if I may, with the effect of Ben Carbushi. Ben Carbushi is in volume 2 of your authorities, my lords. Behind tab 27. Page 574 of your lordship's authority bundle. So, in Ben Carbushi, the Supreme Court considered whether, as a matter of customary international law, a state has immunity in respect of an employment law claim. And if your lordships would turn to paragraph 53 of Ben Carbushi, as a matter of customary international law, if an employment claim arises out of an inherently sovereign or governmental act, the latter is immune. And in terms of determining whether or not an employment claim arises out of an inherently sovereign or governmental act. Paragraph 54, at the top of page 575 of your Lordship's authorities bundles. In the great majority of cases arising from contract, including employment cases, the categorisation will depend on the nature of the relationship between the parties to which the contract gave rise. This will in turn depend on the functions which the employee is employed. And then we have paragraph 55 of Ben Carbushi, the 3 categories of staff within a diplomatic mission. There's no dispute here that the claimant fell within category 2, administrative and technical staff. And just above little letter D in the margin, the role of technical and administrative staff is by comparison essentially ancillary and supportive. It may well be that the employment of some of them might also be exercises of sovereign authority if their functions are sufficiently close to the governmental functions of the mission. And your Lordships may have seen in the authorities references to which side of Lord Sumption's line employees in category 2 fall into. And the question, I don't think there's any dispute about this, although there are disputes about the implication and the proper approach to this test, is whether or not the functions are sufficiently close to the governmental functions of the mission.
And so, just for my purpose, category 1 are almost always going to be on the immunity side of the line. Category 3 are almost always going to be on the other side of the line, and there's a judgment call to be made about individuals who fall in category 2. Category 2 by definition is not one side or the other.
Lord Sumption is more explicit than that, my lord. He says category 1 will always be sovereign functions, category 3
will
cannot
always
conceive
be.
of any
Good.
circumstances. Looking at the end of paragraph 55, important indication of how I say Lord Sumption views this test. The employment of... However, I find it difficult to conceive of cases where the employment of purely domestic staff could be anything other than act jure gestionis, non-sovereign functions. The employment of such staff is not inherently governmental. It is an act of private law character, such as anyone with necessary resources might do. So I say that when determining which side of Lord Sumption's line category 2 member of staff falls, one asks, is it an act of private law character, such that anyone with the necessary resources might do? Are they doing things which they might do in a private capacity by reference to the functions of the individual? So, taking a step back and looking at what this means, I say, many or indeed all of the functions of a mission will be inherently governmental, and all technical and administrative staff, to some extent, support those public functions. Second, the important thing is to look at the individual's personal functions. Is this personal involvement in the governmental functions of the mission, or is the relevant employee carrying out only those activities such as might have been carried out by private persons? And I'll just take you to one example. You'll see at paragraph 56, 2 lines below the letter G in the margin, the United States decisions are particularly instructive because the Foreign States Immunity Act has no special provision for contracts. They therefore fall to be dealt with under the general provisions relating to commercial attractions. And the particular example dealt with, page 576, by B in the margin, it was held that the act of hiring a domestic servant is not an inherently public act that only a government could perform, even if her functions including serving at diplomatic entertainments. So the question, I say, is not whether the role is public-facing, such as it comes into account with those outside the embassy. The question is whether the nature of those functions are sufficiently close to the governmental functions of the issue. Now, moving on to the practical effects of the Ben Carbushi judgment, just to take your lordships how this fits in with the State Immunity Act. Miss Ben Carbushi argued that the provisions of Section 16 of the State Immunity Act, which at that point said that state had absolute immunity in relation to any embassy employment claims brought by a member of a mission, was constituted an interference with Article 6 rights and was an interference with her rights under the Charter. And if you could turn up, please, paragraph 78 of the Ben Carbushi judgment, that's page 584 of the authorities bundle.
Yes.
Article 47 of the EU Charter of Fundamental Rights. The Supreme Court held that insofar as Section 16 of the State Immunity Act, as it then was, prevented any embassy employee bringing an employment tribunal claim, that was inconsistent with Article 47 because it went further than customary international law, regardless of whether or not the claim arose out of a sovereign act. On that basis, in relation to the EU law-derived claims, Section 16 had no effect, and that, of course, is the origin of the indication that the Employment Tribunal gave to the embassy in that March 2019 hearing, that following the decision in Ben Carbushi, it was open to claimants to pursue EU-derived claims, provided that the claim did not arise out of a sovereign. The Supreme Court also found that the decision was a breach of Article 6, and it made a Section 16, I should say, was a breach of Article 6, and it made a declaration of incompatibility. And that led to the effect of the remedial order, which you will find behind tab 2 of volume 1 of your authorities bundle. Forgive me, it's probably more helpful to look at the Act before and after the remedial order. Section 16, as it was before the remedial order and at the time of the Employment Tribunal decision, is page 32 of the authorities bundle. Section 16(1)(a), Section 4 above does not apply to proceedings concerning the employment of the members of a mission within the meaning of convention. So it is an absolute bar on employment claims brought by members of a mission. Lord Sumption in Ben Carbushi said that that was inconsistent with Article 6 because it went further than customary international law, because customary international law only gave an embassy immunity in circumstances where the claim arose out of an inherently sovereign act. As a result of that, we have the remedial order. And if I can take you to Section 16 as it is now, behind tab 1, page 11. So, Section 16(1) little AA. Section 4 above does not apply to proceedings relating to a contract of employment between a state and an individual if the individual is or was employed under the contract as a member of a diplomatic mission. 1. The state entered into the contract in exercise of sovereign authority. So there's no dispute between the parties that in interpreting the statute as it stands now, the state entered into the contract in exercise of sovereign authority. One applies exactly the same test that one would have applied under the Ben Carbushi test, paragraph 55, in determining which side of the line an individual falls, if it is being determined by reference to that individual's functions. In terms of the technical point, of the extent to which the remedial order is retrospective, the remedial order appears behind tab 2. It came into force on the 23rd of February 2023. And paragraph 1.3 of the remedial order, the top of page 20, it is to some extent retrospective. It applies in relation to proceedings in respect of a cause of action that arose on or after 18th of October 2017. And in the claimant's case, some of her claims are about acts or omissions that happened before the 18th of October 2017, but some of her allegations are about acts or omissions which happened after the 18th of October 2017. I don't think anything turns on that because there is no dispute that there has been no change in the test to be applied in the context of this case.
That's a relief.
I should say that was also the position in the Constantine case.
Yeah.
So that is what I wanted to say about the statutory provisions. Before I get to the substance of what I say on ground 2 or ground 3, I also want to deal with what I say is the law about the proper approach that appellate courts should take and what are termed evaluative judgments. Now, in my skeleton, at paragraph 70, I took the court to 2 decisions, both at EAT level, below the Court of Appeal, which suggested that a determination as to which side of the line, Lord Sumption's line, a Category 2 member of staff falls, is a factual determination for the Employment Tribunal. Now, that is what is suggested by those decisions. And it's perhaps worth just looking at one of them. Webster in the USA appears in your volume 3 behind tab 38.
Sorry, Miss Stanley, I was noting something else. Give me the reference again.
Your volume 3 behind tab 38, page 859, my lord.
Volume 3, tab
38.
38.
Thank you very much.
Now, this is an employment tribunal claim, but it's a claim based on a military base, so the State Immunity Act is disapplied in its entirety. So the question of whether a state has immunity is determined on normal common law principles without reference to the State Immunity Act. And if you look at paragraph 43 of the EAT's judgment, page 865,
just to get my eye, Mrs. Webster was employed on the base, dealing with the maintenance, preservation and destruction of records.
yes, ma'am.
And she trained other people to do it.
And we have the statement of His Honour Judge Taylor at paragraph 43. In Ben Carbushi, Lord Sumption distinguished between 3 types of employees. Determining which side of the line an employee in the middle category falls is inherently a matter of factual assessment that is for the Employment Tribunal. The roles and functions undertaken by the claimant puts them in the middle territory. I do not consider that the claimants are able to establish that the employment judge erred in his analysis of whether state immunity applied. He reached a factual determination that was open to him.
And the sentence before you started reading, the ground of appeal is in reality one of perversity.
Yes. Now that is what the decision says. I accept that the question of which side of Lord Sumption's line an individual falls is not a question of fact. It is not a question of fact, as, for example, within ground 1, has the head of mission authorised submission, is a pure question of fact. So I accept it is not a question of fact. But it is a question to be answered by a first instance tribunal based on an evaluation of those facts.
Well, there's two stages, isn't it? The employment tribunal makes findings of fact as to what the claimant did. And those are findings of fact which should have thought are not susceptible to appeal. Then the tribunal makes an evaluative judgment, which is not exactly a question of fact, but it's not a question of law either.
Mixed facts and fact and law.
I agree, my lord, it is two stages, and what I will say is there is a different approach on appeal to both stages.
Yeah.
Both of those stages, I say, require a deference to the fact-finding tribunal, but it is a different approach on appeal. And it is important in this appeal where ground 1, the waiver point, is a challenge, I say, to a pure finding of fact, did the head of mission authorise. In relation to this point, in relation to functions, a challenge to findings about what the claimant actually did, that would be a finding of fact, that would be a perversity hurdle. A challenge to the evaluative judgment of which side of the line the claimant's employment falls is not, I accept, a challenge to a finding of fact. It is a challenge to an evaluative judgment. There is a materially different sort of deference shown to the first instance tribunal when challenging evaluative judgment. I accept it is easier on appeal to challenge an evaluative judgment, but it does not mean that an appellate court makes that decision from the start. And what I wanted to do is just speak very briefly, or maybe not briefly enough, about the law on that sort of challenge. You'll see I've given various examples of paragraph 72 of my skeleton. They are perhaps getting at the same thing, but I do not suggest that those authorities are as on point as the authorities that I'm going to take you to orally. It's worth starting, I think, with what the EAT said about this and why I say the EAT on this point falls into error. Paragraph 88 of the EAT's judgment, that's on page 160 of the report. I also consider that once a tribunal has made findings of fact about the duties of the employee in question, there can logically be only one right answer to the question as a matter of law. It has been suggested that two employment judges could validly arrive at different conclusions, but in my judgment cannot be right. That cannot be done as a matter of individual impression, let alone discretion. And to be clear, I'm not suggesting that a determination as to which side of Lord Thompson's line an employee falls is a matter of discretion. It's an evaluative judgment. It's a question that is not a question of fact, but is based on facts. And in that sense, it is a question of law. I accept it's a question of law, but it is not a question of what is sometimes termed pure law. It's not a question of, for example, statutory interpretation shorn of any factual context. It is an evaluation.
So do you take issue with the statement there that there's only one right answer to the evaluation?
It's difficult, isn't it, my lord, because I think there is only one right answer, but that does not mean that the appellate court can remake the decision without reference to and without deference to the decision of the first instance tribunal, who saw the witnesses, who heard the evidence, and whose even the best of judgments will never be a complete
They
record.
wouldn't be open to the appellate court. So there's only one right answer, and my vote for right answer is the other one. because it's the appellate court's making an evaluation.
It may be that there is one right answer, but in determining what that right answer is, there is a requirement in an evaluative judge when assessing an evaluative judgment on appeal.
So as soon as you bring in the concept of evaluating, then it opens up the possibility that two different judges could come to a different conclusion.
It may well be on the facts that two different judges could have come to a different conclusion. I don't know if I might think about that and
Yes,
come
well,
back to that. Yeah.
Yep.
What I wanted to do very briefly is deal with the law on what is said to be an evaluative decision. And these are the three new authorities that will be at the back of your bundle. I'm hesitant to take you, my lord, to read B.
If what you've just said is right, Stanley, then none of this matters. If what Miss Justice Bourne in paragraph 88 seems to go dead against the concept of an evaluative judgment. Pure law, right or wrong, bang. And as we all know, employment tribunal decisions can only be appealed on a question of law, but concept of an evaluative judgment seems to me to be the antithesis of a hard division. As a matter of law, there can only be one right answer.
Well, certainly that's the approach Mr. Justice Bourne took. You can see at paragraph 97, page 161, his determination. The approach that the EAT takes is effectively simply to reconsider the question afresh as to whether, on the employment tribunal's findings of fact, he falls on the right side of the line. And if he is right about that, in principle, one could go up to the Supreme Court, were one to get permission, simply asking different tribunals to make their own determination on which side of the line these individual falls, without any particular deference being shown to the first instance tribunal's findings on that point. I say that can't be right. That's not the approach taken in the case law to appellate interference with other evaluative judgments.
But paragraph 98, I therefore conclude ground 3 succeeds, although, as I've said, this is a borderline and difficult case.
Well, there will always, I'm not sure I accept that it's a borderline difficult case, but if it is, there will always be borderline and difficult cases.
And it's there's, again, a family authority going back a long time called Re N Hopeless Appeals. I was in many of those. And Lord Justice Ward said that the more narrowly balanced the evaluation is, the less prospect of an appeal succeeding that there must be, because the judge could have gone one way or the other way. And as soon as, to my eyes, you see words like borderline, it becomes much more difficult for the appellate court to say that the previous judge was in error.
Well, certainly I would say that it cannot be right that an appellate court, in considering which side of the line a case falls, can remake that decision as if the first instance judgment was not there. In borderline cases, it is likely that that deference, which I say should exist to a first instance judge, will tip the line because it is borderline. I don't say that would necessarily happen in every case, but in many cases, as a matter of practice, it probably would. But what Mr. Justice Bourne does, I say, is that he takes the findings of fact and makes his own decision without reference to that decision, without deference to it. That, I say, is an approach which cannot be right. And it's not in line with the approach suggested in the other cases on evaluative judgments at all. I don't know if I need to start with it, but the line of authority in many of the appellate cases starts with Re B.
Well, let's go to that. So at the back of the...
Yes, it's 3 from the back, I think.
So, Miss Stanley, having a tidy mind, can we call this tab 51?
Yes, my lord.
No,
We can't.
I've been
because
Tab
there's two others in between.
51 Vienna Convention, 52 Diplomatic Privileges Act, 53 Re B.
53,
And then we've
thank
got
you,
the
my lord.
interpretation of statutes by Maxwell.
That's 50.
53, I think we'll go for.
Well, that demonstrates that my lords have, but I don't, but I can take it up with my clerk at the short adjournment, the 51 and 52.
I don't think we are going to need those before lunch, my lords.
Fine.
We can
No,
sort of
I'm
have
sure
a
I'll be
lunch.
fine. So 53 in Re B.
So, where would you like us to go in Re B?
If I could take you, please, to paragraph 44. This is the statement that one finds at the beginning of much of the recent case law on evaluative decisions. And it's in relation to the decision whether in care proceedings threshold is crossed, whether or not threshold is crossed for the making of a care order. Paragraph 44. On any view, there is nothing discretionary about whether threshold is crossed. I consider in respect of this case, and then at the bottom, the last two lines of paragraph 44, like all other members of the court, I consider that an appellate review of a determination whether threshold is crossed should be conducted by reference simply to whether it was wrong. So, again, hesitate to make this submission to your lordship, but threshold in family proceedings, whether a child is likely to suffer significant harm, and that likelihood was attributable to the care likely to be given to her, is an imperfect summary, as I understand it. That is an evaluative decision taken on the basis of primary findings of fact, and the appellate review of that determination is whether it was wrong. But case law, I'm going to come on to whether what wrong means in those circumstances.
And the distinction being made in paragraph 44 was that hitherto appellate courts had only overturned decisions of that nature if they could hold that they were plainly wrong. And the question was whether plainly added anything to that, and their lordships decided it didn't and shouldn't be used.
Yes, and that, of course, goes back to the use of plainly wrong that we saw in Henderson in relation to ground one. If I could take you now, please, to IBM, and if I could ask you, please, to look at paragraph 414 of this authority. Tab 54, thank you, Ms. Darwin. Now, the issue in question here, it's an enormously complicated factual judgment, but the issue in question here is whether a failure to offer a pay rise in circumstances in
So
which...
I'm having trouble finding the paragraph numbers jump around. What page is it?
Page 1763 of the internal numbering of the authority.
Right. I was going from the transcript, which I can see, which had you down as saying 114, but 414, which is what actually I heard you say.
Sorry, I missed it entirely.
So
Which tab and which paragraph?
It's tab 54, my lord, paragraph 414.
there isn't a tab for 50. It's the case immediately after B.
Oh, I see. Sorry. 1763, not of the bundle, but of the law report.
Yeah.
Okay.
I apologise.
It's paragraph 414 at the bottom of that page.
So the issue in question here is whether the failure to offer a pay rise to which there is no contractual entitlement per se could in principle constitute a breach of the implied term of trust and confidence that subsists in every contract of employment. And the determination at paragraph 4.1.14, which is relevant for the purpose of the submissions I'm going to make, is that in principle it could on the facts, it will be unusual, but the question of whether or not it constituted a breach of contract will depend on the facts, which will of course necessarily depend on the first instance judge's factual findings. And that, again, I say, is treated in the authority as an evaluative decision. Based on findings of fact, does it constitute a breach of contract? And the point I want to pick up is paragraph 416. A submission was made that we had to satisfy that he had been plainly wrong before we could reverse that finding, the finding that failure to offer the pay rise had been a breach of contract. What we say in the next few paragraphs in our judgment properly states the appellate court's functions in a case of the present character. Paragraph 418 at the bottom of the page. Reflecting upon the helpful submissions made to us on these authorities, this is not a case in which challenges are made to the judge's findings of primary fact at all. It seems to us that even if these were put at their highest from the point of view of the RBs, those are the representative beneficiaries for the purpose of the pension scheme, the relevant issues would be largely akin to the question considered in Re B as to whether the trial judge's evaluation of whether threshold requirements have been met. I consider that appellate review of a determination whether threshold is crossed should be conducted simply by reference to whether it was wrong. And this is contrasted, paragraph 420, on the next page of the authority with Henderson, with a different sort of judgment, an appeal against a finding of fact, where the decision was plainly wrong. So we looked at Henderson when I was dealing with ground one. The challenge for factual finding is perversity. The challenge to an evaluative finding is whether it is wrong, and that is different. Turning to the next authority behind that in the tab, which is the Chief Constable of Greater Manchester case, if I could ask you please to turn to paragraph 64 of that authority.
Yes.
This is a challenge on appeal to a proportionality assessment in administrative law, looking at what it means for a challenge for that decision to be wrong, another sort of evaluative decision. You'll see by little d in the margin, the decision may be wrong not because of some specific error of principle in the narrow sense, but because of an identifiable flaw in the judge's reasoning, such as a gap of logic, a lack of consistency, or a failure to take account of some material factor which undermines the cogency of the conclusion. However, it is equally clear for the decision to be wrong, it is not enough for the appellate court might have arrived at a different evaluation. The appeal court does not second guess the first instance judge. It does not carry out the balancing task afresh, but must adopt the traditional function of review. So in determining whether an evaluative decision is wrong, it is, in some senses, a question of law, but it is not considered afresh. It's appropriate. An appellate court should look for identifiable errors in the first instance judge's approach, the traditional review function. And sort of keep in mind the E80's judgment. That is what I say that Mr. Justice Bourne did not do. He considered it afresh. So the last case I wanted to take you to on this point is within volume 2 of your authorities bundle, please. It's behind tab 29. A case called Restriction Limited. please, to paragraph 418, page 624. Page 408, paragraph 418 makes clear that this part
No, is 418 a quote from Sir Timothy Lloyd's judgment in another case, in the IBM case.
Sorry, it's paragraph 71 on page 623. I apologise, my lord. Right. This makes clear the factual context of the sprint room decision.
Yep.
The argument in this case is directed to the judge's evaluative decision as to whether Dr. Potaminios' conduct justified his exclusion from the management of the company, and so whether there had been unfair prejudice in the conduct of the company's affairs on the basis of the primary facts as he found them to be. While there were disputes below as to the primary facts, his findings on these disputes are not now challenged. We are concerned to assess the judge's evaluation of the primary facts, leading to his decision that there had been unfair prejudice in the case. Now, what follows at paragraph 73, 74 and 75 is a consideration of those principles that we've looked at and those paragraphs that I've taken your lordships to in UB, in IBM and in the Chief Constable of Greater Manchester case. And this leads to the Court of Appeal's conclusion at paragraph 76 at the top of page 66. So, on a challenge to an evaluative decision of a first instance judge, the appeal court does not carry out the balancing task afresh, but must ask whether the decision of the judge was wrong by reason of some identifiable flaw in the judge's treatment of the question to be decided, such as a gap in logic, lack of consistency, or a failure to take into account. So, it is a review function looking for errors.
And so that's a direct quote from the IBM judgment.
Well,
we had those words. Was it Lord Carnworth?
Yes, it's quoted in the IBM judgment itself. It's a direct quote from the Greater Manchester case, my lord.
Right. Okay.
You'll see.
That is Lord Carnworth.
Yes. You'll see that is extracted within paragraph 75 of Sprint Room on page 625.
And so this is an authoritative distillation in the sense that Lord Justice McComb was one of the judges in the IBM case, and clearly Lord Justices Leggett and Rose have gone on to other things and are to be regarded as having a degree of authority. But there's a unanimity, you say, in the approach of the 3 or 4 cases you've now taken us to.
Yes, and I say that, I apologise if I'm taking this too slowly, but I'm hoping to be able to put this away and move to the judgment when I've done so. That needs to be read with paragraph 77 of Sprint Room.
These are all very familiar, famous authorities, all to very similar effect. Various branches of the law, we go on to Lord Justice Lewis and island hopping and all that.
Well, I'm grateful for that indication. The reason I have perhaps spent longer than I should on it is that there is, I think, some dispute between the parties of the relevance of Sprint Room. In particular, I say that these principles are in relation to evaluative decisions. They are not in relation to factual findings. And I note in passing that the embassy, within its skeleton, when dealing with ground 1 on the waiver point, paragraph 115,
Which paragraph are you in?
I'm at paragraph 115 of the embassy's skeleton, and I'm dealing, this is the embassy's response to ground 1 of the point about the unsigned statement. There is an appropriate quote from Henderson dealing with the approach to be taken in relation to a finding of fact, but then it is suggested by the embassy at paragraph 115 in Sprint Room that a gap in logic or a failure to take into account is an error of law. Now that of course is true, but that is guidance of the approach that an appellate court should take when dealing with an evaluative judgment, which I say is the type of judgment as which side of the assumptions lie does an individual fall. It's not the appropriate approach of an appellate court in dealing with a finding of fact, which is the point on ground 1.
Finding of fact is perversity, evaluation is wrong.
I agree, my lord, but wrong with the proviso that the appellate court does not remake of its own initiative without reference, but should give particular deference to the first instance decision, bearing in mind the principles that my lord Lord Justice Bean said were very familiar. Paragraph 78, 79, deference, aware of all the facts, island hopping.
Yes.
So, turning, if I may, now to ground 2 of my appeal. In ground 2, the claimant says that the EAT erred in finding that the ET had applied the wrong test in determining whether the embassy had the benefit of sovereign immunity by reason of the claimant's functions. And this is a challenge to the Employment Appeal Tribunal's findings. If I could take you please to the core bundle, page 161. Page 99, paragraph 99. I also allow the appeal on ground 2. This was on the ground 2 of the embassy's appeal before the EAT was that the ET had applied the wrong test on the basis that a lack of precision in the terminology of the analysis contributed to what I have found to be a legally erroneous outcome. And that needs to be read, I think, with paragraph 92 of the EAT's decision, page 160, the core. The use of terminology is of clear relevance to that ground. Applying Ben Carbushi, the test was not whether the claimant's work was ancillary and supportive to the exercise of sovereign authority, it was whether her ancillary and supportive work was sufficiently close to that exercise. I agree that that is the correct Ben Carbushi test. In the passage quoted by the ET at paragraph 39 above, those different tests appear to have been elided. I do not agree that the Employment Tribunal did not understand the correct test and did not apply the correct test. So in order to determine which part of the Employment Tribunal judgment the EAT felt elided the correct tests, that's dealt with at paragraph 39 of the EAT judgment, but it's perhaps best to look at the ET judgment itself, which is paragraph 194 of the ET decision. That's page 212 of the core, my lords. The Employment Tribunal says, on the facts, the claimant's functions were not close to the governmental functions of the mission. They were relatively low-level, ancillary and supportive functions. Now, even if read in isolation, that paragraph does not suggest that the Employment Tribunal misunderstood the sufficiently close test. They were necessarily ancillary and supportive functions because all functions of individuals within category 2 of Lord Sumption's categories are ancillary and supportive. The employment judge is making the determination that they were relatively low-level ancillary and supportive functions. So I say, even reading that paragraph in isolation, it doesn't suggest that the Employment Tribunal didn't understand or didn't apply the correct test. But of course, one does not, my lords, read any paragraph of any judgment in isolation, and it's important to look at the Employment Tribunal's reasons. The Employment Tribunal made very detailed findings about what the claimant did, and for your note, the claimant's evidence as to her job roles are paragraphs 116 to 134 of the core of the judgment, page 199 to 201 of the core. That is her evidence. And page 150 of the judgment, paragraph 150 of the judgment, page 204, the Employment Tribunal accepted the claimant's evidence regarding her job responsibilities. And then we have, at paragraph 181, page 210 of the core, the Employment Tribunal's analysis as to why the Employment Tribunal says that the claimant's employment was not an exercise of sovereign function. One has a look at paragraph 183 of the judgment. On my findings of fact, while the functions of the respondent itself may have been inherently governmental, I consider that all the claimant's duties were truly ancillary and supportive to this. So the Employment Tribunal understands that it's about closeness. Paragraph 184. On my findings of fact, the claimant provided information to her manager for him or the attaché to make the relevant decisions. Her functions were indeed essentially ancillary and supportive to the government functions. This was not a governmental matter, but involved making practical arrangements. Again, the Employment Tribunal understands that the question is whether the claimant's own functions were sufficiently close. Paragraph 186, about the level of information to which the claimant had access. Her role was a purely administrative one. Again, focused on the claimant's functions and about closeness. Paragraph 187, talking about her role in the ticketing department, the last sentence. This had little connection with any governmental function of the mission. Again, the tribunal understands it's about closeness. And then I'd ask you to read in full, if I may, my lords, paragraph 189 on page 211 of the core. This shows my submission that there is a sophisticated understanding on behalf of the employment judge in relation to this matter. Lord Sumption's words suggest that technical and administrative staff in general exercise ancillary and supportive functions. He does not suggest their employment is an exercise of sovereign function simply because they support or assist the governmental functions of the mission. Rather, he says that the employment of some of them might also be exercises of sovereign authority if their functions are sufficiently close.
That's obviously in quotation marks correctly, and it's underlined.
It is.
I stress that because the EAT decision of paragraph 92 is that that's the correct test.
It is.
And there's the ET judge underlining it.
Yes, and I say there is no basis for an appellate tribunal to conclude that the correct test was not applied. It is identified and there is nothing inconsistent in the judge's reasoning.
You're going to go on to paragraph 194. That's where the conclusion is.
Well, paragraph 194 is where I started. That is the
Yes,
paragraph.
I'm pointing to it because close is in inverted commas.
It is.
Again. And so this is the conclusion on the facts of claimant's functions were not close to the governmental functions, relatively low level. So it's that paragraph that must be the target of the EAT's conclusion that the incorrect test was applied.
Yes,
It's difficult to my eye to see how that criticism is sustainable.
I mean, I agree, my lord.
I thought you would.
but I'm
lords
thinking
agree.
if there is a more nuanced point that Miss Darwin may make against me that I should deal with, which is why I pause. I hope this is not intended to be rhetorical. I really do think, my lord, it is as simple as that. What I would quickly take you to is the decision in Constantine about this one.
So it's just partly me being slow. But if the exercise at appellate level is to look at the evaluative decision of the ET, and the appellate tribunal is only to interfere with that if there's been a flaw, the quotation we've taken to. Paragraph 92 of the EAT decision purports to identify a flaw in the test applied, and that's the reason for the decision. So it's important to understand the point that I've been.
I agree with that,
pointing.
my lord. If the employment tribunal had applied the wrong test, that would be an error, and it would be appropriate for the appellate court to intervene. I say in relation to ground 2, so the EAT says two things. It says that the employment tribunal, 1, applied the wrong test, and 2, came to the wrong outcome. I appeal both of those findings, and I've approached it that the EAT considered it in the alternative. He found that Employment Judge Brown, 1, applied the wrong test, and in any case came to the wrong outcome. I accept that application of the wrong test is an error of law. In terms of wrong outcome, that is where my submissions as to the evaluative judgment and the proper approach and appeal come in.
Thank you.
If I could take you please to Constantine, which is in your volume 4. Behind these behind tab 46, page 1182. Now, this is an appeal, again, against a decision of the London Central Employment Tribunal that an individual employed in the Cultural Bureau of the Royal Embassy of Saudi Arabia fell on the right side of Lord Sumption's line, that her employment was not a sovereign function. And it is, I should say, and I don't want to put too much emphasis on this, a decision of Employment Judge Brown, who is the judge who made the decision in the instant judgment before you. And I don't think there would be any dispute, although again I don't wish to put too much emphasis on this, that very many of these embassy employment cases in London Central are being dealt with by Employment Judge Brown. If one could have a look, if your lordships could look please at paragraph 73 of this judgment on page 1203.
Yes.
And you'll see that Employment Judge Brown in Mrs. Constantine's case described her, that's Miss Constantine's duties, as truly ancillary and supportive. And you have the Supreme Court's decision. This is the Supreme Court's decision as to the conclusion of the Employment Tribunal in Miss Constantine's case, on which side of the line Miss Constantine's employment fell. Little paragraph 2. The language chosen was truly ancillary and supportive. And it appears, although the parties' arguments are not set out in detail in the judgment, but it looks as if there may have been some challenge to the judge's use of the statement truly ancillary and supportive. The Supreme Court wasn't troubled by that wording. The judge was simply stating that the case did not go beyond the norm. This is apparent from her careful examination of the judge's role. So suggesting that something is truly ancillary and supportive at an extreme end of an ancillary and supportive category does not, I say, suggest any error in the test applied.
There's a danger of turning the language into highly technical, tight legal verbiage, but one doesn't anticipate Lord Sumption intended that.
No, and indeed, given the type of determination that it is,
it's descriptive.
It is descriptive, and it is necessarily, I say, and this leads on to some of what I've been saying about an evaluative decision, it is necessarily fact sensitive, and there is some authority that I may come to if I have time, saying that appellate court should be very wary of seeking to set up rules or categories when this is necessarily a fact sensitive assessment which will differ from case to case. So that is what I wanted to say about my ground 2, the suggestion by the EAT that the Employment Tribunal had erred by applying the wrong test. My ground 3 is that the EAT erred in holding that the Employment Tribunal had come to the wrong conclusion. And I'd like to take you back, if I may, to the EAT judgment, paragraph 97. So, I've taken your lordships here before, but at paragraph 97 on page 161 of the core, this is, I say, the entirety of the EAT decision on outcome, that the ET applied the wrong outcome. And it is, I say, and this is significant, peculiarly brief. The EAT simply identifies 3 particular activities identified by the Employment Tribunal: sifting compliant and non-compliant guarantee requests, writing reports on funding requests, and discussing art exhibits with visitors and with British students and teachers. She played a part, even a small one, in protecting the interests of the Saudi state and its nationals in the UK and in promoting Saudi culture. This is, it is, I accept, based on Employment Judge Brown's finding of fact, but there is no deference to Employment Judge Brown's evaluation.
Guarantee requests for what? Guarantee that tuition fees will be paid for something, or guaranteed of exhibition costs, or what?
I can take you to the Employment Tribunal's findings of fact on what that means in practice, my lord.
Well, do you know, to save time?
It deals with requests. Students at Saudi Arabia, students at UK universities will request financial guarantee letters, and the claimant effectively dealt with the administrative functions in relation to that. What are, I say, very clear from the Employment Tribunal judgment is she had no decision-making capacity, but she dealt with the administrative functions of those guarantee letters.
Okay.
But so the first point, which I have already canvassed, is that there are 3 points I make in relation to the way that the EAT approaches outcome. The first is that the EAT does not approach this properly, bearing in mind that it is an evaluative decision. The EAT should consider whether it is wrong, and in doing that, the EAT should approach this as a review function. The EAT should be considering if it can identify any identifiable errors. And that is not what the EAT has done in paragraph 72 or within this judgment as a whole. And that is to be...
It may be, to be fair to the EAT, it may be that Mr. Justice Bourne thought that because he was saying the wrong test had been applied, he was therefore thinking that he could redo the evaluation. And that's the flavour of 97, whether it's right or wrong, isn't it? He starts off with the test being wrong, and then effectively, as you say, picks out those points as if he's redoing the exercise.
Well, if that is right, then if I'm successful on my ground 2, ground 3 doesn't matter, as it were. The reason I, in all fairness to the embassy, I should perhaps point out that at paragraphs 98 and 99, Mr. Justice Bourne concludes that ground 3 succeeds in relation to outcome before then holding that ground 2 succeeds. So that order might be said to suggest not that his findings on outcome were dependent on his findings of the test, but that he found them separately.
Okay, fair point.
In terms of what the embassy say in their skeleton about the appropriate approach on an appellate court to decisions of this sort, they take you to what Lord Hope said in Jones and Saudi Arabia, and if your lordships could turn that up, it's behind tab 18 of your volume 1.
Which paragraph?
Paragraph 33 on page 2. Paragraph 33.
Thank you.
Fourthly, this is the Supreme Court, the House of Lords comments on the Court of Appeal decision. The Court appears to have ruled that the exercise of jurisdiction should be governed by appropriate use of development or discretionary principles.
This is Lord Bingham.
This is Lord Bingham, yes.
I thought you said you were taking us to Lord Hope. Maybe I misheard.
I did say that and I shouldn't have said that. I apologise. Thank you, Mr. Owen. The part pointed to in the embassy's skeleton, state immunity is an absolute preliminary bar precluding any examination on the merits. The state is either immune from the jurisdiction of a foreign court or it is not. There is no halfway house and no scope for the exercise of discretion. I agree, it is not a halfway house, it's an exercise of discretion. That does not mean that there should be no proper deference to the first instance judgment's findings of fact. The second case, which I should just have time to take you before lunch, it's a very brief point, and perhaps I'll just deal with it by reference to the embassy skeleton. The embassy takes you to a case called Holland and Lamp and Wolf. This is another House of Lords case. It's not a case on the question of the appropriate level of the appropriate approach of the appellate courts on appeal, and it is also a case in which the relevant state, here the USA, had been found to be immune by reference to an individual's job functions at each stage of the process, at first instance in the Court of Appeal and upheld in the House of Lords. So it was not a case about overturning an evaluative judgment made below. I think I have 2 further points to make about outcome, but it is 2 minutes to 1, and
well, that's
my lord,
probably
that would be a convenient
a
point.
sensible place to pause. And clearly you're at or ahead of your time estimate,
Yes, my lord.
despite the many interruptions. That, well, we off. Good.
2 o'clock.